Every day in the USA, people find themselves in court.
And I think the individual seated at the detention facility's Zoom location would be Samuel Brown.
Yes, Your Honor.
Are you ready to proceed on him, Mr. Pape?
Yes, Your Honor.
All right. Then the court will call State of Kansas versus Samuel Logan Brown. It's case number 2023 CR 300069. Brett Sweeney again appearing for the state. Chris Pate as defense counsel. Mr. Brown from the jail Zoom location. I'll also note Christy Ashenfelder from Community Corrections is with us for this particular case. This defendant has a warrant to show cause pending, alleging law enforcement contact with the sheriff's office and failing to notify his ISO of that law enforcement contact, engaged in physical violence in a Butler County pending case, apparently. He failed to obtain suitable employment. He admitted to methamphetamine use in December. He failed to make payments and was unsuccessfully discharged from South Central Mental Health Substance Abuse Treatment. Those being the allegations, Mr. Pate, what announcement is made?
Your Honor, Mr. Brown is prepared to admit that he's in violation of his probation. As to allegation one, that he had law enforcement contact, he denies that, but he would be prepared to admit the remainder of the allegations. Hopefully that's acceptable to the state and we can proceed in that fashion.
He's denying that he had contact with law enforcement?
That's what he told me, Your Honor. But he is admitting the other 5 violations, which I believe is more than sufficient to establish a material violation.
All right, so he will admit that he engaged in physical violence, which led to the sheriff's case number, but denying that he actually had contact with the sheriff's office.
That is correct, Your Honor.
Mr. Sweeney, your position on this partial admittance of violations which are alleged?
Well, I think I'm not sure how those two necessarily reconcile, but I think I'm willing to go forward on what's been stipulated to.
Very well then. Mr. Brown, you've heard what your attorney has announced on your behalf.
Yes,
You
sir.
do have a right to a due process hearing where the state would have the obligation of proving these allegations by a preponderance of the evidence. You can challenge the state's evidence, put on your own evidence, confront the state's witnesses. Unless good cause was shown, you would have the assistance of your lawyer. And I need to point out that among other lesser remedies, the court could just consider an outright revocation of your probation and having you serve the remaining balance of your sentence incarcerated. Do you understand these things?
Yes, Your Honor, I understand.
Do you waive a formal hearing in this case and stipulate and agree that you committed all the violations except the contact with law enforcement?
Yes, Your Honor, I waive.
All right. And then you admit those other 5 violations.
Yeah, I mean, you can't cut the red tape. I can make all the excuses that I want, but I did violate. I was, there's no God violated. Yes, sir.
All right. Court finds that the defendant freely and voluntarily waives a hearing in the case and stipulates to the violations 2 through 6 in the warrant to show cause, which is currently before the court. These are substantial and material violations of the terms and conditions of Mr. Brown's probation. Court will now turn to disposition in this case. I'll ask for recommendations, starting with Mr. Sweeney on behalf of the state of Kansas.
Yes, Your Honor. So the state is recommending a revocation in this case. We show that the underlying was 8 months in Department of Corrections. We're asking for that to be revoked. We show, as of up to today's date, 115 days of jail time credit against that sentence. I would note that I wasn't the prosecuting attorney on the sentencing, but I would note that at least according to the felony journal entry, that it looks like Mr. Brown was presumptive prison, and in placing Mr. Brown on probation, the court made a finding that an appropriate treatment program exists, and so the fact that there's problems now with that treatment program, I think that's a grave concern that I have, and one of the reasons that the state's making the recommendation for outright revocation. But also note that he has apparently had an internal sanction that sounds like would qualify as a dip for the graduated sanctions on 10/11/24, according to the ISO. So I think, not even based on anything at the initial sentencing, I think that if a graduated sanction needed to be met, that it's been met through that internal sanction. So I just think the 8 months DOC is appropriate in Mr. Brown's case. That's all I have, Your Honor.
Very well. Mr. Pate, your recommendations regarding an appropriate disposition here?
Your Honor, we would ask the court consider reinstatement with an appropriate sanction. Mr. Brown was also on probation on 23 CR 106. There was a PV hearing in that matter for, I believe, the same violations. I was not the attorney on that. It's my understanding Mr. Brown received a sanction through April 24th on that case. I'm not entirely clear if that's just a sanction and close, or if that matter was reinstated after that sanction. Mr. Brown was presumptive prison on this case. It was not due to his criminal history. He was a criminal history score of H at the time of sentencing on this. It was due to a special sentencing rule, or actually, I've got to retract that. It was the person felony with a deadly weapon special rule that was in effect here. So it was presumptive prison special rule rather than via criminal history. Mr. Brown did have employment during periods of his probation. He worked at Kansas Paving for about 5 months. He worked at Simmons Well. He worked at C&G Drilling. He, as I said, did have jobs during various portions of probation. A lot of it boiled down to transportation issues and things of that nature. He did do a officer imposed quick dip several months ago in this case. So I do agree that has been satisfied. It would seem to me if the court outright revoked Mr. Brown with the time served, and if he got his good time, there's probably only a couple months left. But Mr. Brown would like an opportunity to complete probation. We would think a sanction of an appropriate amount, longer than a quick dip, at the court's discretion would be appropriate, and then reinstate the probation after that. If the court does not wish to reinstate probation, we would ask the court consider a sentence modification as well.
Very well, Mr. Pate. This time, the court will address the defendant, Mr. Brown, personally and ask him if he has any statements that he wishes to make in mitigation of punishment here, or anything further that he would like to present to the court.
Yes, Your Honor, I would. First, I'd like to say, in my defense, on the violence, the contact of the police officer, that was the day I had a probation meeting. So if I would have been at home, I would have had contact, but my nephew had punched me in the face because I had told him about his dog. Long story short, he hit me. I tried to stop him from doing that, and I accidentally headbutted him. And then I left. He had a bloody nose because I tried to wrap him up, and my head bumped him while he was struggling. I took him to the bathroom so he could stop his bloody nose, and I was almost late for my probation meeting. I wasn't aware that they'd called the ambulance. His little brother was freaking out because the nose bleeding hadn't stopped. So he had called for an ambulance, and law enforcement showed up, and I wasn't aware of that until later that evening. As far as the treatment, I was in contact and doing my meetings with Miss Ashfelter, and she told me she didn't want me to treatment hop, but I was allowed to change treatment if I didn't feel like I was getting from treatment what I needed. So that was due to the reason that I was scheduled to do 7th Direction instead of South Central. I was doing the best that I could. I also moved to El Dorado back to Butler because of work, and that's the transportation issues. There were some issues with drug and alcohol there as well, because I was trying to get meetings switched. And so I was trying, I just wasn't aware of how intensive intensive supervision probation was in community correction. Now that I've been in here and I've sat in here for a little while, I have completed a 12-step program in here. I've completed a substance abuse program since I've been in here. I'm also enrolled back in school. I've got my high school diploma set up through here, and I'm ready to continue that if I'm let out on probation again. I've come in here and I've used my time willingly, and I've understood that I've violated. There's no excuse for the violation of the methamphetamine use. I did use, I slipped up underneath stress, and I'm in that constant battle of addiction. And I feel like I'm coming full circle religiously. My mind's better, cleared out. I feel like I'm more prepared this time for community corrections, and I don't think I will fail this time. With that being said, I'm in here busting my tail, and I mean, I am guilty. I did violate, and regardless of your guys' decision, I understand. You guys have a job to do, and I hold no qualms with y'all. And I just ask for forgiveness. I'm sorry for the work that I've provided for you guys, because I know you guys' workload is already overwhelming. With that being said, I'm sorry, and that's about it, sir.
Ashton Felter, you're a representative here from the Community Corrections Department, and your name was brought into this discussion. So do you have any additional information or any position that you would take personally regarding this matter?
Your Honor, I would agree with the state's recommendation.
Counsel, there are some legal issues which this court sees that has not been discussed. The fact that he was presumptive prison due to the firearms rule, does that allow this court to bypass an intermediate sanction prior to sending Mr. Brown to prison? Your Honor, it's presumptive prison only by special rule, not by criminal history.
To the extent that's posed towards the state, I had the same thought in the lead up to today's hearing, and I wasn't sure. So when they told me that he had already had an in-house dip, the state was essentially basing its recommendation on the dip as opposed to the it's not a circumvention, but the allowance for the remand based solely on the fact of the departure. The state was basing it on the dip that was done.
All right, thank you, and I appreciate your candor, Mr. Sweeney. Everyone on this meeting's time is valuable to this court. I don't make light of that, but I'm going to declare a recess until 3:15 p.m. I would like the detention facility, if possible, just to leave Mr. Brown in his current location, leave and stay on the meeting. I'll come back on at 3:15 p.m. hopefully, and the court will announce its decision regarding disposition. There are some matters I want to look into before making a decision regarding Mr. Brown. So 3:15 p.m. I'll rejoin the meeting and hopefully be in a position to make a decision on the case at that time. We're currently in recess for a period of 15 minutes. Following recess, the court reconvenes in State versus Samuel Brown. Mr. Sweeney, Mr. Pate, Ms. Ashenfelter, and Mr. Brown appearing from the jail, all as before. Court did declare a recess in this case to consider the disposition of this matter. Mr. Brown, this is a bit of a struggle for the court. If I'm really looking purely what you deserve and what you don't deserve, you probably ought to be on your way to DOC. Your statement today was one of two things, Mr. Brown. Either it was a very carefully thought out and delivered message that you're trying to get me to accept just to try to get out of trouble, or it is statements of a definite commitment that if you were given one more chance, you would fully take advantage of it. Quite frankly, only you in your heart know which one of those two it is, because quite frankly, the court hears both. Mr. Brown, I don't make light of the fact that you've messed up in the past and that you've had some sort of dip sanctions imposed by your officer. Those are clearly allowed by law. They're meant to wake you up and get your attention so that you don't have to appear back before the judge again. I also note that you did have a presumptive prison case at time of sentencing. In a general sense, that gives the court more latitude in revocation matters, but I will note that you did not receive a dispositional departure in this case. Rather, it was essentially a special sentencing provision, which gave you an optional non-prison sanction in the case. Those are different in the view of the court. Further, quite frankly, Mr. Brown, I'm impressed with your statement here today. You appear to have thought about this and have a plan if you were to be given another chance. I don't know what your real chances of success would be if you were given another chance in the community. Mr. Brown, I think I'm inclined to give you that one last chance. I'm not sure you've earned it, but I'm going to give you an opportunity to earn it in the future. Despite your officer recommending against it, she's worked with you. She doesn't think that that's a worthwhile endeavor. Neither does the prosecutor. We'll see. They very well may be right, Mr. Brown. But you get this one last chance. This court will, as a sanction for noncompliance, impose a prospective 3-day dip in this case on Mr. Brown, which means, Mr. Brown, you've got 3 more days in jail to serve before you're released back onto community corrections on this case. Any condition that came up before that you haven't fully satisfied remains. Ms. Ashenfelter, what direction would you give Mr. Brown when he gets out Monday at about 3:30? What direction would you give?
Sam, if you just want to call me when you get out of jail, and we'll schedule your next appointment.
Yes, ma'am.
Okay.
And I think he's going to be in there till the 24th because of a sanction on another case.
All right. Well, then I need to make this order. Thank you, Mr. Pate, for your candor. If the cases that are involved here are mandatorily consecutive, he needs to serve 72 hours at the end of the sanction period that he's currently serving. If they are not ordered to be consecutive, then they're going to run concurrently. And the next 72 hours dip time is essentially running along with his other sanction. Mr. Pate, can you answer that question?
I believe they are consecutive. I'm looking at the journal entry right now.
I don't have anything in my docket notes that I ran it consecutive to any other case. That doesn't mean that the other case wasn't run consecutive to this one. Christy, do you know?
Yes, Your Honor, I was just about to say something. So 21 CR 223 and 23 CR 106 are concurrent, but 23 CR 150 is consecutive. What they did at his prior revocation hearing is they gave him 30 days for all 3 cases.
Okay, all 3 other cases that he has?
Yes.
Okay, but this one is going to run consecutive to at least one of those.
Yes.
All right. Mr. Brown, then we're going to attack 3 more days on at the end. But that's here still this month that you'll be getting out. And then you need to call Christy either the day you get out or the very next business day after you get out.
Yes, Your Honor.
She may have you come right on into the office. I don't know. But I think if you at least make telephone contact when you get out or the very next business day, you can get back perhaps in good graces on your community corrections on this case and perhaps successfully complete. You made some commitments to me today, Mr. Brown, and you made them to yourself that there's some things you're going to take care of if you get another chance. Like I said, this very well may be your last one.
Failure is not an option.
No, it's not. Failure puts you in a prison cell.
Yes, Your Honor.
I think you know what the stakes are here.
Yes, Your Honor.
All right. I hope I'm not wrong about this one, Mr. Brown. I took extra time to think about this. I read this as a case where you could still be successful on all of this.
Yes, Your Honor.
Sounds like you're going to be facing some major time between this and other cases if you fail. So, as you say, failure is not an option. You heard Christy's recommendation, but I have no doubt that if you do what you're supposed to do, she'll work with you and she'll get you through this, but you have to make all the effort.
Yes, Your Honor.
All right. I'm going to waive any additional bids assessments on this round. Not that Mr. Pate's involvement hasn't been very valuable to the defendant. I just think that with his multiple cases and his period of incarceration that he has faced and is facing, that it's not financially viable to assess additional amounts. Anything that was previously ordered, though, remains on the books to be paid. Okay, don't take this wrong, Mr. Brown. I hope I don't have to see you again.
I won't see you again. I hate to say that, but you won't see me here again.
Okay. Well, I like the resolve in that statement. Let's see if you can follow through, Samuel.
Yes, sir.
All right.
Thank you.
Mr. Sweeney, was there any other case-related matter that we still need to address? I did want to kind of look at where he was as far as probation period. He had an initial term of 12 months, which would take us to April 19 of 2025. Was there any other extension already put in place here, Christy?
No, Your Honor, I think he does need to be extended.
I'm going to extend you through the remainder of 2025, Mr. Brown. That's plenty of time to get your requirements done. So on this case, you're extended to 12/30 through 12/31 of 2025. All right.
Thank you, Your Honor.
Anything else while I was dealing with that come to mind, Mr. Sweeney?
No, Your Honor.
Mr. Pate, anything further we need to address currently?
Just to clarify on the concurrent or consecutive, I did find the misdemeanor journal entry, and it says 23 CR 106 was to run consecutive to 23 CR 150, but there isn't anything in this case stating concurrent or consecutive. So as I understand it, Mr. Brown would then get out on the 24th if that's his out date.
Well, wait a minute, Mr. Pate. Are any of those cases running or mandatorily consecutive to this one?
They're all misdemeanors, so I don't think there would be any special rule.
That wasn't clarified for me earlier. So every one of those other cases are misdemeanor cases?
Yes.
All right. Then you are absolutely right, Mr. Pate. It is not the intention of the court to run additional time on to misdemeanor sanctions. It is a prospective order that this court is making. If there's no mandatory or court-ordered consecutive to a felony involved here, the next 3 days that he actually serves will count toward this sanction.
Okay.
Since he has more than 3 days to do, he's going to satisfy it on the 24th. Well, actually, 3 days from now, he'll satisfy this sanction, which would be on the 7th. But then he's going to have to finish out his time on the other case. Another good job that your attorney's done on your behalf, Mr. Brown. He just saved you 3 days of lockup. All right. Thank you for that clarification, Mr. Pate. We don't want to base extended time on false assumptions, and I regret that. Okay. Mr. Brown, do you have any questions about what we've done here today?
No, sir.
Okay. Just remember, don't forget to call Christy as one of the first acts that you do when you get out, okay?
I will, Your Honor. I won't fail you.
All right. Good luck. I hope you're successful on this, Samuel.
I will be. Thank you, Your Honor.
If there's nothing further, the Samuel Brown matter will be in recess at this time. Mr. Sweeney, I am not aware of other matters to be addressed on this docket. Are you?
No, I'm not, Your Honor.
Very well. Thank you for your time here this afternoon, as well as yours, Mr. Pate. There's nothing further. This will conclude the docket at this time. This meeting may be ended for all.
Thank you.